Hi, I'm Chris Harrow with Keller Williams Realty. Here are some ground rules about agency relationships in South Carolina. South Carolina law requires real estate licensees, real estate agents, like me, to provide you one of these. This disclosure, plus a meaningful explanation of South Carolina agency relationships offered by the licensee's brokerage. By law, this has to be done at the first practical opportunity when you have substantive contact. Click the link below to download your own copy of this for further reference and review. As a real estate consumer in South Carolina, it is your choice as to the type and nature of services you receive. When we talk about real estate licensees, that's anybody who has a license to sell real estate. Me or any other real estate agents, brokers, licensed salespeople representing new home builders or community sales offices. Before you begin to work with me or any of those other licensed salespeople, it's important for you to get a thorough explanation of your rights and options as a South Carolina real estate consumer. It's the law, and it helps you be a more informed real estate consumer. First, you need to know the difference between a broker in charge and associated licensees. The broker in charge is a person in charge of a real estate brokerage firm. Associated licensees can work only through a broker in charge. In other words, when you choose to work with me or any other real estate licensee, any realtor or agent, your business relationship is legally with the brokerage firm, not with the associated licensee. Legally, your business relationship is with my locally owned Keller Williams brokerage firm and not me personally. A real estate brokerage firm and its associated licensees can provide buyers and sellers valuable real estate services, whether in the form of basic customer services or through client-level agency representation. And the services you can expect will depend upon the legal relationships you establish with the brokerage firm. It's important for you to discuss the following information with the real estate licensee, me, and agree on whether in your business relationship you're going to be a customer or a client. Now, you're a customer of the company. South Carolina license law defines customers as buyers and sellers who choose not to establish an agency relationship. Licensed South Carolina real estate agents are required by law to provide the following basic duties when dealing with any real estate buyer or seller. We got to present all offers in a timely manner. We must account for money or other property received on your behalf. We got to provide an explanation of the scope of services to be provided. We got to be fair and honest and provide accurate information to everybody. And we got to disclose adverse material facts about the property or the transaction, which are within the licensee's knowledge. Unless or until you enter into a written agreement with a brokerage firm for agency representation, you are considered a customer of the company, and the company will not act as your agent. As a customer, you should not expect the brokerage firm or its licensees to promote your best interest or keep your bargaining information confidential. These are services real estate agents are likely already providing for their existing clients. Customer service does not require a written agreement, so you're not committed to the brokerage firm in any way. Unless or until you sign a written agreement for agency representation, you're considered a customer. So customer level service is the default. That's your first option. And your other option, you can become a client. Clients receive more services than customers. If client status is offered by the real estate brokerage firm, you can become a client by signing a written agency agreement, requiring the brokerage firm, its agents, and associated licensees to act on your behalf and promote your best interest above all others, including their own. When you sign a buyer agency agreement, I'm not just working with you, the brokerage and I are working for you. If you choose to become a client, you'll be asked to confirm in your written representation agreement that you've received this brochure in a timely manner, along with a considered explanation. A seller becomes a client of a real estate company by signing a written listing agreement. For a seller to become a client, their agreement has to be in writing and must clearly establish agreed terms and obligations for both the seller and the brokerage firm, which becomes the agent for the seller. A buyer becomes a client of a real estate brokerage by signing a buyer agency agreement. For a buyer to become a client, the buyer agency agreement must be in writing and must clearly establish the terms of that agreement and the obligations of both the buyer, and the brokerage firm, which becomes the agent for the buyer. If you enter into a written agreement as a client, you can expect the real estate brokerage firm to provide the following client-level services: obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care and skill. Client-level services also include advice, counsel, and assistance in negotiations. Without a written agency agreement, you should not expect any of those services to be provided. Next, we'll go over definitions of some key terms relating to South Carolina agency relationships. Single agency. Single agency is when the brokerage firm represents only one client in the same transaction, the seller or the buyer. That's called single agency. Dual agency. Dual agency exists when the real estate brokerage firm has two clients in one transaction, a seller client and a buyer client. At the time you sign an agency agreement, you may be asked to acknowledge whether you would consider giving written consent allowing the brokerage firm to represent both you and the other client in a disclosed dual agency relationship. Disclosed dual agency. In disclosed dual agency, the brokerage firm's representative duties are limited because a buyer and seller have recognized conflicts of interest. Both clients' interests are represented by the brokerage firm. As a disclosed dual agent, the brokerage firm and its associated licensees cannot advocate on behalf of one client over the other and cannot disclose confidential client information concerning price negotiations, terms, or factors motivating buyer-client to buy or the seller-client to sell. Each dual agency agreement contains the names of both the seller clients and the buyer clients and identifies the property. Designated agency. In designated agency, a broker in charge may designate individual associated licensees to act solely on the behalf of each client. Designated agents are not limited by the brokerage firm's agency relationship with the other client. Instead, they have a duty to promote the best interest of their clients, including pricing negotiations and advice. The broker in charge remains a disclosed dual agent for both clients and ensures the assigned agents fulfill their duties to their respective clients. At the time you sign an agency agreement, you may be asked to acknowledge whether you would consider giving written consent allowing the brokerage firm to designate a representative for you and one for the other client in a designated agency situation. Each designated agency agreement contains the names of both seller clients and buyer clients and identifies the property. With a better understanding of those terms, here's what to look for in an agency agreement. When you choose client-level service, your written agency agreement or agent should answer the following questions. Can I work with other companies during the time of the agreement? What will happen if I buy or sell on my own without the agent? When will this agreement expire? How will the company be paid for its services? Does this company represent both buyers and sellers as clients? If so, what are the choices if two clients become involved in one transaction? What duties will the company continue to provide me after the transaction is completed? And if you plan to become a client of a company, the licensee will explain the agreement to you fully and will answer questions that you might have about the agreement itself. Remember, until you enter a representation agreement with a company, you're considered a customer. As a real estate consumer in South Carolina, it is your choice as to the type and nature of services you receive. You can choose to remain a customer and represent yourself, while the company represents the other party. You can choose to hire the company for representation through a written agreement. If represented by the company, you can decide whether to go forward under the shared services of a dual agency or designated agency, or to remain in single agency. As a South Carolina real estate consumer, the choice of services belongs to you. I hope this short explanation has been helpful and you're making a more informed decision about South Carolina agency. If you have any other questions, feel free to call or text.